Welcome back, everyone, and thank you to all of our wonderful audience members who spent the last 2 days with us. As I said, it's bittersweet that it's coming to an end, but we have a great presentation ahead, so looking forward to hearing from Billy, Joshua, and Russell. We're so humbled to have such a great turnout and such an engaged audience. So we encourage you to send in your questions throughout and appreciate all of your participation so far. We're also so honored to have had so many knowledgeable industry experts on the panel to share their insights into the profession. And this presentation is no exception, as Russell will be sharing the panel with Billy Tarasio of Modern Law and Joshua Lennon of Clio. So I'll share a little bit more about our speakers in just a moment, but I'll let you know what you have to look forward to over the next hour. And just a quick note for all of our lawyers in the audience, this program has been accredited by the LSO and contains 1 hour of professionalism content. So getting into our agenda, so our panelists will get started with a quick intro to AI, integrity and responsibility to the profession. We'll also discuss competence and client communication, as well as confidentiality and privilege. We'll get into the billable hour versus block fees, supervision of lawyers, law students, and staff, our judicial orders banning artificial intelligence tools reasonable, and can lawyers even comply? We have how firms are currently implementing AI. And lastly, we have using AI as a discovery tool when your clients drop off a box of random documents, international regulations impacting small firm use of AI. As I mentioned, our panelists will do their best to answer as many questions throughout the presentation. So if you have any burning questions, please send them in through the Q&A. Right, so get into some background on our speakers. So thank you again, Billy, for joining us. Billy Tarasio is the founder of Modern Law, a firm based in Mesa, Arizona, where she has been pushing the boundaries for how to build a successful law practice since 2008. She is also the creator of Access Legal, a cloud-based document automation software for clients to help them create their own forms and filings, ostensibly with the coaching help of an attorney or paralegal. Still, clients were not always comfortable creating legal documents, but technology continued to drive the bottom line in her firm, where she developed techniques to tweak results that she's been sharing with other lawyers around the country. Through her experiences and driven by metrics, Tarasio has developed the steps to create and assess changes to any law firm and drive measurable increases in company profits, which ultimately serves clients with better service. Next, we have Joshua Lennon. Thank you to Joshua for joining us as well. He is the lawyer in residence at Clio, one of the first and most successful legal technology startups. There, he helps Clio with privacy and compliance issues in 78 countries around the world, while also contributing to a larger legal technology industry. Joshua participates in various legal education, access to justice, and legal technology initiatives, including Evolve Law, the previous Reinvent Law movement, and Legal Hackers initiatives. And last but not least, the brains behind this operation, we have our founder, Russell Alexander. And I was lucky enough to, bring it on. I was lucky enough to have a bit of a sneak peek while we were preparing for this presentation and got to hear a bit of what Billy and Joshua and Russell were going to be talking about. So I know this is going to be a very interesting discussion, and I don't want to take up any more of their screen time. So I'm going to pass things over to Russell to kick off the presentation.
Thank you, Shannon. And once again, thank you for all your hard work this week. It's been outstanding 2 days. Let's run our first poll. Earlier today, we did a more substantive dive into AI. Today's going to be more about professional responsibility and what the profession and legal service providers should be considering. Got a fantastic panel with us. So what are your feelings on artificial intelligence being used in the practice of law? Just a very brief intro, and Shannon, maybe you can drop in the links to our previous programs on AI if people want to do a deeper dive. But artificial intelligence rapidly changing the legal industry, transforming the way lawyers work, offering new opportunities and increased efficiencies. It's the development of computer systems that can perform tasks that would typically require human intelligence, learning, problem-solving, decision-making. They use algorithm and system models to analyze data and make predictions. They can be trained to improve accuracy and performance over time. As I mentioned earlier today, a lot of us are already using AI in our daily lives and may not even be maybe not even know it. Social media feeds, email spam filters, online shopping, traffic predictions, customer service, chat bots, news feeds, and a whole bunch more. So that's AI in a nutshell. You can learn more. Look for the links. But let's see what our audience is thinking right now and how they feel about AI. Interested in learning more? That's great. 81%. You're in the right spot. Isn't reliable yet? Well, there's an argument to be made for that. I don't know if I'd agree with that. Don't trust AI. There is lots of suspicion, especially with hallucinating AI. Too difficult to learn. Again, interesting perspective and other, you can throw it in the chat box. But let's talk about integrity and responsibility to the profession. And Joshua is going to take the lead on this. If you don't mind, Joshua, what do we need to know?
Absolutely. Thank you. Pardon me. I've got a bit of a frog in my throat, so let me know if I'm not coming through clearly. Thank you so much for bringing me on to talk about this. I'd like to share a quick screen, if I may. Ooh, and I'm not allowed to. Oh, I got it now. And what I'd like to bring up is, quite frankly, how interesting it is that we're dealing with AI. And so that poll that you just took was actually a poll that we ran as part of Clio's Legal Trends reports. And we ran that poll with not just lawyers and legal professionals, but also with clients, whom you can see in the dark blue here. And so you can see that in the general population, lawyers are less interested in learning more about AI than the people attending here. And I actually am encouraged by that, because I think it tells us that you guys are leading the pack. And so if you're interested in learning a little bit more about the Legal Trends Report, it has been included as a downloadable resource for this presentation, and you can also grab it here. When it comes to the risk in using artificial intelligence, lawyers are much more concerned with the ethics of it than clients. Clients are more concerned about whether or not malpractice will cover any mistakes made by AI. And also, they are a little less worried about trusting law firms to use AI, which is something that's interesting to me. When we look at the ethics, and I am a New York trained attorney, so I tend to look towards the US ethics on this. There are a number of the rules of professional conduct that are used throughout the United States that really apply here. And one of the bigger ones is actually, I am showing you the wrong screen, aren't I? Oh my gosh, give me 1 second.
You've got rule 1.1. There we go. Yeah.
There we go. Rule 1.1, which is competence. And it was actually added in 2012 and has been adopted mostly across the US now. And it tells us that lawyers need to consider both the benefits and risk of relevant technology. And I think this is actually a really expansive guidance. I do think as we look towards artificial intelligence, there are benefits and risks that can be applied to the practice of law. But arguably, this is probably the strongest rule that is saying, as these benefits become more apparent, that we as an industry need to start considering using and adopting tools that have these benefits. The risks tend to be in these other rule areas. So confidentiality of information. One of the interesting things about some of the free tools that are out there is that they oftentimes use us as the training database for their continued improvement. And so we do have to make sure that if we are utilizing these tools, that we're not contributing towards the training of them, because they may be storing information in a way that violates the confidentiality rules of our particular jurisdiction. One example of this is ChatGPT. They have both free and paid versions through the developer OpenAI. Only in the paid versions can you label your chats secret and not contributing to the payment to the development of their system. However, the exact same technology of ChatGPT has been licensed by Microsoft. It's available and you can kind of run your own using their Azure data hosting. And those can be run and used where you're training your own copy of ChatGPT rather than the public one. And it shows how this technology can be configured to utilize both our rules and our ethical requirements in a way that meets them. When we are reviewing the output of generative AI, we have to remember our responsibilities when it comes to looking at and supervising non-lawyer services, and that includes technology. And so it is beholden upon us to actually reach out to these tools, make sure we understand what they're pulling from, how are they generating this material, and then reviewing the outputs itself. And those outputs could be things like advertising rules that are still in existence in many jurisdictions. It could be in communications to clients. It could be submissions to the court. And we've seen, unfortunately, some really public examples of lawyers in New York who used generative AI to create submissions, put them to the court, and it turned out that those submissions had hallucinated citations is the kind phrase we're using there, which led to sanctions being used against the lawyer because they did not take their supervisory responsibilities to task. Now, when it comes
Avianca Air, you want to read the case, Avianca Air, and it's a real warning sign for some lawyers, that's for sure.
Yeah, I think the one other funny takeaway from that case is that when the judge was initiating sanctions against the lawyer, they did note that the sanctions probably would have been higher, except the lawyer has received global attention and ridicule with this mistake. And so it's not just your relationship with the court or your clients that might be at risk, but your global reputation. So supervising is incredibly important.
I think I would balance that because all the lawyers I know freak out when they hear about that particular case. But that's an AI model working on data that's 2 years old. It's not current. And I think in terms of word crafting and document prep and automation, it's fantastic. But I don't want somebody to read that New York Times article in that case and say, okay, I'm not touching this.
Oh, yeah.
There's still a lot of power and a lot of use to be made with AI.
I totally agree with you. It's more that, again, you have to take that supervisory approach. And so I always treat this generative AI as the first draft, not the final.
Right.
Interestingly, when lawyers are saying that they're worried about the ethics of these tools, and I'm not, there we go. Sorry. That's not coming up, even though it's showing on my screen. One of the things that they're saying is close to 20% of lawyers surveyed say that they don't think bars will ever approve these tools. But what we're seeing is a large number of bar associations and law societies really beginning to tackle these already. What you're seeing here are proposed changes to the Florida Rules of Professional Conduct that will be voted upon in December 1st, where they're specifically calling out artificial intelligence as not just a tool that can be used in the practice of law, but a tool which has its own concerns when being included. And so bars are taking this into their own considerations with task force in New York, the Texas State Bar, the California Bar, as well as Florida, all working behind the scenes right now on crafting ethics opinions. And we know the American Bar Association in the United States is also launching a task force that will be issuing ethical guidance around this. So I think that belief that bars will never approve these tools is actually out of bounds. We see they're already saying these tools will be a part of your practice, and here's some guidance on how we think to better utilize them. And when clients are looking at the risk associated with it, again, we talked about with malpractice coverage, they actually, a plurality are, well, a third are saying that they do think it can be used to be providing legal advice, and that can be used to make legal decisions. So there are going to be clients who rely on this. Now, are they relying upon a ChatGPT that was trained 3 years ago and asking it questions? Or are they asking a lawyer who is utilizing these tools? I think that's something that needs to be discussed. And I do think that there may be a good business case, if not an ethical case, for disclosing some of the tools that you're using to your especially savvy clients. So 70% of clients are telling us that they want to know if their law firm is using artificial intelligence. But interestingly, less than half of lawyers believe that. And just barely over 10% of lawyers think the clients could figure it out anyway. So when it comes to the ethics of utilizing these tools, it's pretty much the same ethics as any other workflow. Be competent, take a supervisory role, and make sure that you're preserving the client's confidentiality when utilizing this. And it's just like any other tool. It's actually somewhat shocking how much law firms are actually looking at this as a risk as opposed to a benefit. And that's it for my section here, Russell.
That's great. A lot to unpack there. And I really appreciate you sharing your study with our audience. Let's go to our audience and ask poll question number 2. And Shannon, while that poll question is up, are you or do you plan on using AI? Let's just pop down to slide 15 because I want our Canadian lawyers to be mindful of the Ontario rules. So, yeah. So in Ontario, one more. These are the rules you want to be mindful of. 2.1 with respect to integrity and responsibility to the profession. 3.1 competence. 3.2 communication. Very similar to the rules that we're just going through in the US. 3.2 honesty and candor. 3.3 confidentiality and privilege. 3.4 avoiding conflicts of interest. These are the rules of professional conduct for Ontario, the Law Society of Ontario. 5.1 candor to the tribunal, that's disclosure and transparency. 5.1 representing a client resolutely, and 6.1 supervision of lawyers and students. So we'll get back to the supervision question in a bit. But so Ontario has very similar rules, different numbers, but I think the general principles are the same for most professions across North America, most lawyers practicing law. So let's see what our audience is thinking about planning on using AI, or are you using? Currently using 19%, no, but I plan to start. 44%, no, and I do not plan to start. 22%, and other 14%. You can throw that in the box. Thank you, Shannon. So let's go back to competence and client communication. So I think I have you on this one too, Joshua, and the next one as well.
Thank you. So when we come to competence, I think there are a lot of different questions that are based upon the use case for artificial intelligence. And what's really interesting is it can be used in a variety of different ways. And so I think one of the first things we need to be asking ourselves is, what is our intended use for this artificial intelligence tool? Is it something that will be used internally? Is it something that will be used externally by clients? Is it something that we'll be submitting the results for? Just like we talked about with the lawyers who submitted a brief to a court during the case. So for competence, while that's not a duty in Canada, what we do know is that there is conversations around the use of technology in terms of productivity, and making sure that you are doing so in a way that aligns with your professional responsibilities. So it means that oftentimes you either have to become familiar with the technology such that you can describe it if somebody's asked and needs informed consent, or have an expert on hand that can do that for you. And I think that second part is something that is often overlooked when it comes to obtaining technological competency, is we lawyers oftentimes are very quick to pick up many concepts, if not processes. And so we think we can do the same for technology, but it does leave us sometimes, unfortunately, biting off a little bit more than we can chew. So when it comes to competency in artificial intelligence, what we should be looking at is its use case. Can we get a full view of what's training that artificial intelligence tool? And can we adequately explain why it is the best fit for this particular use case. Now, those sound like big questions, to be perfectly honest, but most of the time, what we're going to see is these large language learning models actually are pretty straightforward. They've scraped the web. It's mostly public information. They may or may not have guardrails around certain types of legal information. Like, we will only cite to existing cases within our database. And then training yourself on these tools and using these tools is something that there are a growing number of experts that can help you with. So getting competence is actually not as hard as you think on these tools, but does require a little bit of due diligence. Now, when it comes to client communication, I do think there's a little bit of concern about how is the tool communicating? Is it communicating directly with clients, like say a chat bot? Or is it creating drafts that are then being reviewed by professionals within your law firm? I think in terms of public communications, it's just fine for generative AI to be communicating directly to clients, so long as they know that it is a program and not a person, that it's being used for a specific purpose, like say intake of client information, and that it is not providing anything that can be deemed legal advice or legal guidance, but instead has an escalation program that brings in a legal professional if that's the case. So competence and client communication go hand in hand. How are we using this tool? With whom is it communicating? And what's kind of the off-ramp or double check method that we have for this tool? And if you keep those in mind, generative AI can become an incredible client screening tool and drafting tool to help with your communications.
All right, let's go back to our audience and just jump ahead a little bit. Will AI kill the billable hour? I want to thank Joe and Terry Ann, who just donated to the Virgil Center in support of women who are victims of domestic violence. Really appreciate that. That puts us at 75% of our target. We're just under $7,500. So thank you, everybody. Terry, Joshua and I have been talking for a while. Do you want to get in on some of these topics while we're waiting for the poll? Billy? Sorry, you muted.
So, okay, a couple thoughts I have. The conversation that we're having surrounding professional responsibility is the exact same conversation that we have been having for the last 10 or 15 years regarding the cloud. The exact same conversation. It is not at all different. And so that's very interesting to me, you know, having just been around and seeing this. And what does that mean? It means that we're going to see adoption the same way now everyone is using the cloud. Everyone will be using AI. And in fact, I think you're probably already using it. I know that many people said they're not using it, but I think you are. So we're on Zoom right now. Zoom has built-in AI through like 3 or 4 different platforms. They've got Zoom AI Companion. Anything that does transcriptions and summaries is AI. So I think that it's a big thing that we think it's some big, huge thing that's brand new in here, and it's actually been around a long time, and it's just evolving really quickly.
And if you think about the programs we're using, you know, everybody's going, ooh, we got to tell them about AI. We're not telling about DivorceMate, Westlaw, the cloud. You know, this is just another tool in the lawyer's toolbox. If we were to produce a list of all the software and technology that supports our practice, it would be 2 pages long or even longer, right? So that's a great point, Billy. Thank you for bringing that up. All right, let's see what our audience is thinking about the billable hour, because this is going to be an interesting discussion we're going to get into. No, the billable hour is here to stay. Well, they said that about paper, right? We've been using paper for 200 years. The pandemic blew that out of the water. Yes, block fees are the way of the future. Well, Billy and I know a lawyer named Lee Rosen who've been advocating block fees for 30 years and quite successful with it. Depends on the area of law and the practice. So that's interesting because real estate lawyer and a lot of estates lawyers are already doing block fees. So that's kind of an interesting insight as well. So let's come back to confidentiality and privilege. I just want Billy to talk about the billable hour and block fees, because this is an important question lots of lawyers are facing. If we adopt this technology, how do we bill for it, right? How are we going to get paid? That 3-hour financial statement's now 30 seconds. So what do you think, Billy? Billable hour versus a block fee?
I think this is personally one of the hardest issues. I really do. And I have experimented with technology and flat fee billing and block billing for years, and it's hard. I think it's hard, but so I don't think it's a black and white answer. There are some things that we do that can really, in my opinion, as a litigator, only be captured by time. And then there are other things that I think we are going to be able to capture in blocks. So I personally believe, and we are working on in my firm, a hybrid model and a hybrid fee agreement.
And a lot of it depends on the complexity as well. We've tried block fees for collaborative practice files, and a lot of them were upside down. It's a difficult item to say. It's not, it's not like we have a blue book where we're going to go get our car fixed and the brake job's going to be 2.3 hours. Your collaborative settlement can go from 5 to 20 hours. So that's the hard one to gauge. But Joshua, your thought on block fees?
So looking at Clio's data, 90% of law firms use hourly billing on at least some of their matters. And in fact, 87% of all matters stored at Clio, and this is in the millions now, use hourly billing. We do see some specific practice areas that are more likely to have flat fees, criminal defense, immigration, for example. But when it comes to family law, it's still hourly, almost entirely. So what I do think is interesting about the two, though, is no law firm is required to be one or the other. And so Billy's hybrid model really appeals to me, to where you could be offering certain components at a block fee, and then anything beyond that can be more. Or if we're taking a look at your collaborative negotiating, maybe it's not a block fee for the negotiation, but per day of the negotiation. And so there's a subtle but positive reinforcement that if you're going to be stubborn on this issue, sure, it's another day on your bill, right? And that's one way we can do block fees rather than hourly fees, but still add some time components into them.
Right. The earlier AI discussion we had today, we were talking about, lawyers being replaced by AI. You're not going to be replaced by AI. You'll be replaced by somebody using AI. And they're going to level the playing field. So you may be billing your hourly rate. They can deliver the services more efficiently for a block fee. You're going to be out of business, or there's not going to be a lot of clients who are going to choose to use you. So I'm thinking, or I'm predicting, the market's going to level this off. It's going to demand block fees. The other thing maybe we'll get into is, this idea of an unauthorized practice of law. Somebody overseas or another country practicing in Arizona or Washington or Ontario, delivering legal services. How are our governing bodies going to govern that? The horse is out of the barn. How are we going to regulate people giving advice and preparing documents out of state or out of country? So that's going to be another pressure point I see on the billable hour. But let's go back to, we jumped over a point because I wanted to get into this. Sorry about that, Joshua.
Oh, no problem.
Confidentiality and privilege. Let's wrap up this bow and finish this discussion.
So right now there is, as we talked about, a lot of concern about the free tools that are using our input as training materials. And I think that's rightfully so. Anytime you're not paying for a service on the internet, you are the product that is in turn being sold to others. And it's not limited to these generative AI tools. And so what we need to be looking at instead is those tools that allow us to have contractual control of our data when being used with them. And so it's beholden upon us, just as when we hire any other type of service that we do our due diligence, read the contractual terms and keep on top of those terms. Now, it's been shown that only something like 13% of the public read any type of privacy or user agreement when it comes to utilizing an app. Unfortunately, that numbers are about the same when it comes to lawyers. And so this is something that just needs to change if you're going to be jumping into these tools. I am happy to report, though, that there are more and more of these tools that are providing what's called a sandbox function. And that's the idea of you having a pool of your own data that it works within. And it doesn't go beyond that. And it doesn't contribute that pool of data outward into these training modules. And so VLEX, for example, is offering one of these services right now. So if you are worried about confidentiality and privilege, read the terms of service, read their privacy policies, but also know that there are new and emerging functions that give you these strong artificial intelligence capabilities without necessarily having to throw everything up onto the internet for that model to use.
And for Canadians, I mentioned this earlier, you want to be mindful of the US's Patriot Act and where your data is being stored. If you're using Amazon or other data cloud-based servers, some of those data servers are in the US. So that means the US government can access your client data. So you're going to want to use servers that are based in Canada. So you want to be, like Joshua said, really take a close look at that. If you're using these products or service providers, where your client's data is being stored. And it goes back to that discussion Billy raised about, cloud services. That was a big discussion we had several years ago when we started moving to the cloud. Okay.
Russell, could I push back on that one? Actually, I'm going to be a little controversial.
Fire away.
I think the US is just fine for most Canadian lawyers, to be perfectly honest. If you look at the privacy legislation at the federal and provincial level in Canada, there is almost no hard requirement that your data be stored within Canada. It needs to have terrible protections. Now, the Patriot Act is a bit of a boogeyman because
our governing body,
exists under Canadian law.
Our governing body and the Law Society Act requires us to make sure our data is secure. I know it's not likely to happen, but if you're in the US, your data could be subject to attack or seizure by the US government under the Patriot Act. That's a fact.
Yes, but your files in Canada can be seized by law.
If your data is in Canada, the US government's not going to get to it.
No, but the
cloud service providers are.
Yeah.
But we're talking about extreme cases. I'm just saying you want to be mindful of what's written in the contract and where your data is stored.
Yeah, I do know where your data is stored. I just think the idea that Canadian data centers are immune from seizure is just not as accurate.
They're immune from the US government.
It's a risk storing your data anywhere.
They're immune from the US government and spy agencies operating out of the US. So I'm not trying to be paranoid, but Canadian laws, Canadian jurisdiction apply to service providers in Canada. So, all right. So will AI, let's go to the next poll. Will AI increase or decrease lawyer demand? So this is sort of the theme of the discussion we're having today with respect to professional regulation. So let's throw that up there and see what our audience thinks. In addition, if you guys have questions for Billy, Joshua, or I, please put them in. We're going to try to get to as many questions as we can. And we'll see what our audience thinks of this. So Billy, increase, decrease demand? What do you think?
I think it'll increase. So I know this is a guess. I'm not entirely sure, but I think as people actually become more knowledgeable about their legal issues, they will become less overwhelmed by the idea of talking to lawyers. They will be better able to articulate their specific questions. And I think the legal market is going to expand. And I think it'll look different. As you said, the unauthorized practice of law, the availability of new services to help people directly with their legal problems will happen. And that will be an issue for our regulators. But I think in general, our legal market, we've been talking about the latent legal market for gazillions of years, my whole career. And I think maybe this will help us tap into that latent legal market.
Clients are going to become more sophisticated, right? They're going to understand their legal problems better. And just like the pandemic with Zoom, lawyers are going to be more available, right? They're going to be more efficient. If you think of it traditionally, prior to the pandemic, the biggest complaint about family law, takes too long and it costs too much. You'd call a lawyer, you might not get an appointment for 2-3 weeks, or they might not call you back at all, right? So this is freeing up our schedules. It's making us more efficient. We can use all the products and services in terms of intake forms and streamlining clients and chatbots and all the other tools that are out there to help us understand this is the right client for our firm and sort of tailor the client to the law firm. But Joshua, what do you think? Increase or decrease?
Oh, I have to go with the standard answer of it depends. Yeah. So I do think we're going to see legislatures and other agencies try to use artificial intelligence instead of our traditional court structures, right?
Yeah.
And so it'd be like, throw in your questions and we'll spit out an answer. And so at that input point, it's going to be decreasing the demand for lawyers because it's just going to be a kiosk somewhere. But it's a one-size-fits-all solution that never works. And so a lot of those people who go into that system are going to exit it unhappy with unfair outcomes, and they're going to turn to lawyers to help them. I think the one thing we as a profession should be doing is actually reaching out to a lot of these big providers and making sure that they do know when they are potentially at risk for the unauthorized practice of law, and encourage them to be working with lawyer referral services and law societies to have guided off-ramps from AI into the legal profession, such that we can be working hand in hand. They prep the clients, we help the clients.
Yeah, there's a lot to unpack in that answer. We're seeing cases where judges are using AI to write their decisions. We're seeing cases where AI is doing a mediated result. AI is very good at predictive outcomes, right? Mm-hmm. And so I guess the hub here, if we have predictability and certainty, we can advise our clients more accurately what the outcome is going to look like and hopefully encourage settlement. Mm-hmm. But we're losing the discretion, right? That's built into the judicial, the judge's discretion to make a decision based on the facts that are before him or her. So this is sort of an interesting dialogue. But our audience says increase 13%, decrease 57%, no change 30%. Probably should have put depends in there. That's a classic answer.
Everybody would have picked it.
Yeah, it's the default one. So thank you for that. Let's go to supervision of law students and staff. So I got to pull my book up here that Billy helped out with an endorsement. Thank you. Lawyers who supervise or work with other lawyers, students have responsibility to ensure that they comply with the rules of professional conduct. They're pretty much universal, I think, across North America, the principles. Well, in using AI in practice, lawyers have supervisory positions to ensure those under their supervision are using the technology in an ethical and responsible manner. So what that translates to is your associates or your law clerks or your intake team, they're using it, you're still ultimately responsible to ensure it's being done properly. That would be my take. But Billy, what do you think about supervision of lawyers, law students, and staff?
Well, so I think there's a couple of things. We have to treat AI as if they are legal interns. So if your legal intern makes up cases and you turn in your work, you've committed malpractice and you have not been competent. So and that's the exact same thing with AI. But then I also think we have a duty to teach our teams about AI, how to use it, how to communicate about it. So that's something that we're frequently talking about within my firm.
Yeah, Joshua?
I think there are probably two additional points that I can raise to this. And one is the American Bar Association actually issued an ethics opinion on reviewing the work of contract employees. And one of their conclusions was it is ethical to bill for that time reviewing the work that you're supervising. And so while many people talked about the billable hour potentially going away, I think where the billable hour becomes important is applying that professional judgment to these tools. And so, yeah, it wrote a first draft, but I know, for example, that this particular judge doesn't like the way this is formatted or ordered or the citations. And so I'm going to go through and change that. And that's a value add that is billable according to the American Bar Association. The second thing that I think a lot of lawyers don't realize is there can be risk well beyond that of just an ethics violation. Within the United States, we've seen lawyers who have been, unfortunately, brought up on charges by the Federal Trade Commission for participating in basically like debt collection mills, where they're shooting out just, hundreds of filings per hour. And so supervision of lawyers isn't a of these services isn't a rubber stamp, but instead you actually do need to be able to put in the time and the attention and judgment there. So make sure you're keeping that time available and have a means of kind of documenting your contribution, but then bill for it, bill for all that value you add.
Yeah, it creates a couple of interesting issues, right? Let's just say you do this document as a block fee. Now you're going to review it, or the client may have changes. So Billy, would that be as part of the block fee? Do you charge in addition to that? Some of the reviews are normal, but some could be quite extensive depending on your client.
So when we have done this in the past in my firm, when we have had document generation as billed as flat fees, that has included revisions, it's included filing the document. That's how we've decided to treat it. But I think it's something that you have to define and then communicate.
Right. Joshua, your thoughts? I guess the review would be in addition to any block fee or included in a block fee?
I think it depends on how you want to structure the cost. So in Billy's example, right, they were charging more to make sure that they covered themselves for those filing fees, which have to be included, and potential review time. And so on some of those, they're going to come out ahead, right? There's not a lot of review, and some they're going to come out a little bit underwater, like you talked about before, because there's just too much back and forth. So I think depending on how you communicate it, it can work either way. So yeah, here we're happy to give you this first draft. If you read it and need changes, then it will be at this billing fee. Our hourly fee is just fine so long as you communicate it.
Right. Now let's just push the box a bit here. Let's just say, do you think a lawyer, we have a duty to be up to date with technology and deliver efficient legal services. Do you think there could be a complaint against a lawyer for being negligent or incompetent for not adapting AI into his or her practice? You want to take the first shot at that, Joshua?
Yes, actually, we know there was a case regarding attorney's fees in Ontario where the judge wrote down the legal research fees because they claimed that artificial intelligence could have found this easily.
Right.
I don't think they quite were accurate in that depiction, but I think it is an example of how the public and the judiciary are going to be looking at our billed amounts and question whether or not we are operating as efficiently as possible.
We'll try to get that case for our audience in the show notes. That's interesting. It's sort of the opposite of Ivanka error, right? That relying too much on the AI is kind of causes a bit of a problem. But what's your take on those issues, Billy?
I mean, fees come down to the reasonableness standard. So right now, if in your current practice, you're only sending letters and refusing to email, I think you're unreasonable. I think those fees are unreasonable. I think passing them along to your clients are unreasonable, and you failed to keep up with technology. And the same thing will happen with AI, but it's going to be a ways off, because right now it's perfectly reasonable right now today for lawyers to not use AI and not understand AI. And at some point in time, that will no longer be the case.
All right, so let's get into judicial orders banning artificial intelligence tools, and can lawyers even comply? And we're also seeing judges requiring the lawyers to certify what document, whether it's produced by AI and oversaw by AI. But I see we have a poll coming up here. Will AI increase or decrease the risk of lawyer discipline? Yikes, nobody likes the idea of discipline, that's for sure. So, well, let's see what our audience is thinking. So we'll leave that up for a minute. But Joshua, what about judicial orders? I don't know if they can fully ban the use of AI, but what's your take on this?
You mentioned the rule of candor towards the tribunal. I think if a judge is asking if you're using these tools, you should of course tell them and be perfectly honest. But I do think an order banning an artificial intelligence tool is probably an abuse of discretion at some point, especially as these tools just become ubiquitous and unavoidable in many cases. If Westlaw, Lexis, and Canley and VLEX are all relying upon these tools at some point in the future, how do you do legal research without them?
Right.
And so at that point, I think you can't comply and may have to inform the judge that while we respect your authority and are committed to following the rules of this court, unfortunately, we cannot provide adequate representation to our client under this order. And so can we have a discussion on how to put these into place in a way that also addresses the court's concerns?
All right, and I see the articles are being put into the chat, so thank you, Joshua and Shannon for doing that. So, and we'll include it in our show notes after today's event. So we'll send that to our audience members. What's your take on that, Billy?
I think it's completely beyond their authority and discretion. I think that would be an abuse of discretion, and I think we would start noticing that judge every time they got appointed. We would just no, because absurd. That's my thought.
All right, but some of them are doing a full ban. Some of them are requiring certification as well.
No problem with certification. Notice is fair. Notice to your clients is fair. I really think we need to be looking at our fee agreements. I really think we need to be including, we're looking at redoing our fee agreement and making sure to disclose to our clients that we're using all of the latest modern technology, which includes artificial intelligence, and that they should ask any questions if they have them. So getting permission in advance is a great CYA for lawyers, I think.
But I mean, judges saying, if you're filing this document with the court, you need to certify
That you have not used any artificial intelligence at any point.
Or if you have, you need to identify it. I think there's some judges out of Texas doing that.
I don't think there's a problem with that.
Okay.
But it's hard to say like where that starts and stops, right? If I'm getting a roughed draft from AI and then I'm redoing it, it's really no different from getting a rough draft from my paralegal. So then I would have to figure out how to disclose which portions to attribute to AI. I don't know. What would you do?
You'd almost need a schedule of the various software that, I use Google Maps to get to the courthouse. So I include that, right?
Right. You'd have to go over the top and just pile it on.
Put as much in there. It'd be like one of those bank contracts for the mortgage documents. But the, Ontario lawyers are required to make certain certifications pursuant to our Divorce Act that we complied with the act. And I don't imagine it would be much different than that. But what's your take on that issue, Joshua?
I think certification on whether or not you're using these tools, or that, again, based on just our normal certifications, that the information included is factual and true to the best of my knowledge, right? Is probably enough. So whether or not a witness is fabricating something or an AI is fabricating something. So if you are doing your job and double checking the facts and the documents themselves, you're going to be catching that stuff and then submitting the true version to the court.
All right, so let's see what our audience thinks. Increase the risk of discipline 30%, decrease 6%, about the same 24%. Our governing body needs clear rules and regulations to address 39%. Clearly, we want to know exactly what our regulating bodies are expecting of us, so we can make sure that we comply with the rules of professional conduct. Okay, I can't believe we're already trains coming into the station. We've got another 10 minutes, but we've got lots of time. If you want to put your questions in, we'll try to get some questions at the end. But how are firms currently using AI? Now, Billy, I know you're an early adopter and you're always ahead of the curve with respect to the way you run your practice. What are you doing in Arizona with AI, and how's that helping your clients?
So we are using it a ton in marketing. I think the easiest, lowest hanging fruit is with regards to marketing. So we'll take short form videos, put those transcripts into AI, create blogs from that. So it's really useful in creating content and repurposing content. The first thing I did when ChatGPT came out was let go my writer because ChatGPT can do it and can do it as well as any outsourced writer. The other thing that we use it for, if we get stuck with something, like somebody asked the other day in Slack, does anybody have any language on the possession of embryos? It's very easy to ask for, give me language regarding this. Here's what I'm trying to do. Or anybody have any cross-examination questions for this fact pattern? You can put all of that into AI and get yourself a rough draft. So you should never be stuck or never have writer's block. That's how we're using it now. We're also looking at Doc Equity, which is a sponsor here, and they are doing some really outstanding, exciting things. But that right now for us is really the extent of how we're using it inside the firm.
Excellent. And you forget, we're always thinking of document drafting and research. The marketing side of AI has just exploded, and chatbots, hugely effective, like you said, generating content. We have avatars now. So we have an avatar of me. I can give it a script. It'll produce a video. So traditionally, we would have a camera crew and lights, and we switched over to iPhones. We're still doing some editing. Now I don't even show up. I just give the script and it produces it. It's not perfect. You could, if you look closely, you could still tell it's computer generated, but you can see with advances in software and computer power, it'd just be seamless. You're going to get probably deep fakes of audio and video people you might think are your clients or coworkers. You want to be mindful of that. Marketing calendars, write out a 30-day marketing plan for promoting the Family Law Summit, for example, and boom, there you go. Day one, you're going to post this. Day two, you're going to post that. I really like it for blind spots. So if I'm doing a factum or an argument, I'll say, what arguments have I overlooked? What's my opposing counsel going to argue? And think through, is there any merit to those arguments? So it's really good at finding blind spots. Responding to GMB reviews, writing basic letters, hiring staff, doing the job ads, everything. The list is really endless. But what about you, Josh? What are you seeing firms doing in implementing AI?
Well, in our own legal trends report, we found that just like the survey here, only about 19% of lawyers are describing themselves as actively using AI. And while there are a lot of places where they want to be using AI, so in terms of calendaring, time tracking, being able to capture more time, and being able to generate documents, what we've found is the two largest components of work that they're using this for is legal research. So of the 19% of lawyers who tell us they're using AI, a little over a quarter of them are using artificial intelligence for legal research. And a lot of them are using smaller tools like case text, as opposed to Westlaw or LexisNexis. And then another quarter, again, of that 19%, are telling us they're using it for drafting documents. And for that, they're turning to tools like Grammarly and other online drafting tools that will take a look at their work and make suggested edits along the way. We do see that several people are using ChatGPT as well to help provide those types of first drafts. But oftentimes the ones that are more desirable by lawyers are things that actually plug into Microsoft Word. So there's a really interesting one that I like called Spellbook, which is for contract drafting. And it's actually a plugin for Microsoft Word. So it sits in Word and can be evaluating your document. You can use it, chat input to say, write a paragraph using the already defined terms in this contract to talk about, using Billy's example, embryo ownership.
Mhm.
And so it will pull in like all the names and the defined terms that you already have and spit out 1 to 3 versions of a contract section that you then can just cut, right, and paste into your Word document without having to leave it. So we do think that there is a lot more use cases like you talked about, for example, when it comes to imagery and video, but we're not seeing a lot of lawyers currently using that. It's very heavily focused on research and document generation.
The other thing that I didn't mention was document summary. So if you have a large amount of information, plugging that into AI and telling me like what are the main points here, that's really helpful to me.
Yeah. And I think that actually leads into this point here, like using AI as a discovery tool.
And precedent clauses as well. Let's touch upon this real quick, Joshua, and then we'll get to international regulations. So maybe a minute or so on this one.
Yeah, I actually think there's a really good tool out there. Ask Your PDF. And it is a tool that you basically can use a chat interface, and you put the documents in and you can ask questions about it. And so as we get the big box of documents, and while the program's name is Ask PDF, it can actually use a whole variety of different types of documents. You can just say, you know, what is the name of the 3rd grade teacher? How much were they spending on insurance in 2029 or 2021? All right, you can let this scrape through the documents for you and pull that information out, and you can even tell it what format you want that in, right? So this information's on 8 different pages, but I need it in bullet points in a short paragraph. Pull that together. And so it does a lot of that work for you. And there are even more tools that are coming out to do this. And so when clients are dropping off those reams of text messages as screenshots, or they're giving you like the last 10 years of financial and bank statements, don't feel like your first job should be reading them all line by line, but instead let AI do that for you. And then you can go back and verify that against the original documents.
Okay, international considerations. What do you think?
Absolutely. So probably the biggest one coming down the pipe right now is the Artificial Intelligence Act out of the European Union. And why I'm raising this is we know that these large scale regulations out of places like the EU end up impacting technology providers globally. And so right now, this act is in the final negotiation stage in the European Union, with a final version expected to come out in January of 2024. And what it does is it requires AI providers and AI users to take a look at the chances that the risk potentially associated with the use of this tool. And as those risks increase, that there's more and more time for human intervention. And I think that just aligns perfectly with what we've talked about as the supervisory role for lawyers. You have to understand the benefits and risks of these technologies, but as the risks become greater, that just is more and more opportunities for lawyers to be contributing. So expect in early January, a lot of discussion around the EU AI Act, different providers having to make disclosures as a part of their due diligence and be more transparent in how the tool is working. And that global regulation actually becomes important for you as you're doing your due diligence in your smaller firms.
And we're just approaching our 1 hour mark. I would send everybody to OECD.ai, unique source of real-time information analysis and dialogue that's designed to shape and share AI policies across the globe. So there's academic papers. You can go to whatever country you're interested in. It'll tell you what AI policies and procedures they have in place in your rules and regulations. But I see that Shannon's back on, and I cannot believe we've already done an hour. It just goes by so quick.
Time has flown. Thank you so much, Billy and Joshua, for joining Russell today for this discussion. It was really interesting. I know I learned a lot today, so thanks so much. So on that note, we're going to wrap up. Russ, did you want to, there's a resource that maybe you can talk about as well.
Yeah, we've talked about it. The book's out there. It'll be in the show notes. Let's give it everybody on, and Joshua, Billy, that was a fantastic discussion. Thank you so much for your time today.
Great to see you both. Thank you so much.
Thank you.
Have a great weekend, everybody. Thank you for
Thanks,
joining us.
everyone. Take care.